Hi, everyone. Welcome to today's program, Parameters of Practice for Law Students and Not Yet Licensed Law School Graduates. This program is brought to you by the ABA Center for Professional Responsibility and the ABA Law Student Division. My name is Meredith Parnell, and I will be serving as your moderator today. Joining us as a panelist today is Janice Coxum. Janice is Bar Counsel for the Unlicensed Practice of Law Department of the Florida Bar in Orlando. Before we get started, I have just two reminders. So the first one is that ABA membership for law students is free, but there's also the option for premium membership, which comes with some great benefits, including a savings of $250 on Barbary Bar Review, $25 off West academic casebooks, and a legal ethics bundle that includes a free Model Rules of Professional Conduct ebook. To upgrade to premium, you can do that for $25 per year, and you can sign up at abaforlawstudents.com/gopremium. The other reminder is that ABA law student members can join the Center for Professional Responsibility as one of their 5 free entity membership options. I do this, I really recommend doing it to help ensure that your educational and practice goals place a high priority on ethics and professional responsibility. Ethics research assistance, model rules, articles, ethics opinions, publications, and educational opportunities are all available to you from the center to help you both in your classes today and also in your practice tomorrow. So with that, let me just hand off the program to Janice.
Thank you, Meredith. Hello, everyone, and thank you for joining us today. In most jurisdictions, there are parameters that have been set up to keep non-lawyers from engaging in the unauthorized and unlicensed practice of law, or otherwise called UPL. And those parameters are set up by way of rules, case law, and statutes. And those same parameters are applicable to law school students and law school graduates as well, because the students and the graduates are also considered non-lawyers because they have not yet been admitted to the bar. So consequences for the law school students and law school graduates who violate those rules can be more so problematic because it can have an impact on their future ability to be admitted to the bar, to a state bar, and other consequences as well. In the most extreme form, it can also bring some criminal charges. For example, in Florida, UPL is a third-degree felony. And, of course, the prosecutor's office would have to make the decision as to whether to prosecute based on the circumstances. But the option is still available for them to make that charge. I had a respondent, and that would be the person who is the subject of a UPL investigation, who at one point he purported to be a law school student, and he showed up in court to represent a criminal defendant. His argument to the court was that he was representing the defendant as a, quote, attorney in fact, and not in law, so that made it okay. The judge warned the individual that he couldn't do so, and the criminal defendant was instructed to retain counsel, and the case was continued. The respondent later returned with the same criminal defendant. At that point, the judge held him in contempt, and he was incarcerated at the time. The prosecutor's office prosecuted him for a UPL for criminals under the criminal statute, and the bar also prosecuted him for civil injunctive relief, and he was found guilty after a trial. So that is the most extreme case of what could possibly happen to someone who engages in the unlicensed practice of law. So today we're going to look at 3 scenarios that we consider real-life dangers where violations could occur for either law school students or law school graduates. And we're going to look at 3 hypotheticals, and 2 of them you'll be able to participate in a poll, and the first one you will be able to do that. And while there are the situations that may come up in this area, we decided that these 3 are the most common areas across several jurisdictions that can pose problems for law school students and law school graduates. So the first scenario involves those that we tend to hold near and dear to our heart, our family and friends. So this is the first typo. Your favorite uncle is a contractor who is having problems collecting debts from his clients. You two are having a conversation over family dinner, and he asks if you can help him. He tells you that he would hire a lawyer, but with the number of clients who have not paid him, he can't really afford to do so. You know that your uncle wouldn't ask if he weren't really desperate, and your entire family is looking to you to help save your uncle. You're in the second semester of your third year of law school, and you do have some collections experience in your job as a clerk, and you're fairly confident that you could handle this case on your own. But should you? We're going to open the polls now. And bear with me. It looks like the majority of you said no, you shouldn't, which is a good answer. Absolutely not. You should not help your uncle. In spite of what your family may want you to do and the level of skill that you have, the answer is no. A lot of times, family and friends, they are not aware of the restrictions and limitations that are placed on law school students and law school graduates, for that matter. They may not know that first you have to sit for the bar exam, and then you have to be admitted after going through the character and fitness background screening. So it may be tempting for you to try and help out your family or your friends, but it's not worth the risk of compromising your future license in order to do that. And most of the time, if you explain that to people, they will understand that. A real-life instance where this happened, a law student in Texas decided to try to collect a debt for one of his relatives by writing a demand letter to the debtor. The law student made up some stationery that had his name on it, and below it the phrase, quote, student at law. The local UPL committee contacted the dean of the student's law school. The dean called him in and reminded him that he was subject to the same disciplinary rules that licensed attorneys must follow. The dean also reminded him that before he could obtain a law license, he still had to qualify with good character and fitness from the Board of Law Examiners, and that took care of that matter. In a case that I had in Florida, a law school graduate who had not yet received her bar result, but she was still going through the background and fitness and character screening, she decided to help her father with some contested evictions that he had for some commercial properties that he owned. She drafted the pleadings for him. She went to court with him for moral support, but she didn't approach the bench with him. She sat in the gallery. The judge questioned her father in open court and on the record about the source of the pleadings, because the judge noticed that the pleadings had a lot of legalese and the level of sophistication to the pleadings. The father says, my daughter wrote these documents for me. So the judge then calls her up, swears her in, and he begins to question her. She admits that she drafted the pleadings and that she coached her father as to what to say when he arrived in court. And the judge then asked about her knowledge of the law, and she explained her status as a law school graduate, but she was not yet admitted to the bar. The judge at this point is very upset. She is chastised on the record about her conduct, and he then refers the matter to the bar for further investigation. The committee reviews the case, and the Board of Bar Examiners also gets a copy of everything, and her application is put on hold. So the UPL committee decides to offer her a cease and desist affidavit to sign. She hires counsel to represent her in the UPL matter. She also has to hire counsel to represent her before the Board of Bar Examiners, because then, as a result of the UPL complaint, she has to have a hearing. So in the end, it was not worth it. It might have been cheaper for her to just hire a lawyer to represent her father than to go through all of that, and then to also have her admission held up. And in that case, the judge felt that she should have been held to a higher standard because she went through 3 years of law school and she graduated and she took the bar exam, so she should have known better. The second scenario that we're going to look at is jumping the gun, law school graduates jumping the gun. And this is someone who has graduated from law school and received their JD, their Juris Doctorate, but they may not have yet passed the bar exam, or they may not have been sworn in, but they're anxious to offer their legal services to the general public because they figure it's only a matter of months before I'm admitted to practice, and they want to let the public know that they do have the JD, and they work so hard to get the JD, and they just want to hit the ground running. So this hypo, the law school graduate decides to hang up her own shingle. In preparation, she has stationery and cards printed. She sets up a web page and several social media pages. And in order to avoid confusion, she believes, she places JD after her name. She then begins to hand out her cards with her information at networking receptions and other events in hopes of getting a running start once she is sworn in. Although her Facebook page states that she is a JD, people begin to ask her legal questions on her Facebook page. She thinks that the designation of JD clearly communicates the fact that she is not yet licensed. She begins to provide answers to the inquiries in hopes of building a client base once she is licensed. So the issues that are presented in this scenario is, one, is it permissible for this graduate to order stationery, business cards, set up a web and social media page in anticipation of obtaining her license? And the answer to this one is it depends. She can order stationery and business cards, but she should not hand them out to anyone because at this point she has not been sworn into the bar yet. She can set up a web page, although I would not advise to do so, but she should not go live with the web page. As far as social media is concerned, that typically goes live immediately, and so she should avoid setting up any of those pages until she's obtained her license. I have received referrals from the Board of Bar Examiners based on information that they found out about an applicant on the internet while running a search where the person was holding themselves out as a lawyer prematurely. And that was part of their response to the UPL complaint, was that they set up this web page, they paid someone to do it for them. They didn't realize that the web page was going to go live. They thought that the person was going to wait. Long story short, the web page went live prematurely. The Board of Bar Examiners finds out about it, and there's a complaint against them, and also their application is being held up until the complaint is resolved. So I would not recommend setting up a web page. Even though you think it may not go live, things sometimes happen. The second issue is, does the use of JD send a clear enough message that she is not a licensed lawyer? The answer to that would be no. Using JD is something that many jurisdictions go back and forth about, because technically the person is a law school graduate and they have earned that distinction, they have earned that degree. But the important question is, what impression is being given to the public by that person using that JD distinction? Several states have issued ethics opinions, and they're in general agreement that it may not be enough for a law school graduate to simply list the JD credential on law firm or any other communication without further explanation. State Bar of Michigan opinion states that listing academic credentials on a firm letterhead or business cards, even though it may be accurate, it might mislead prospective clients into thinking that the graduate is authorized to provide legal advice, and it could be considered as false and misleading in violation of the rules of professional conduct. There's also Florida case law from the Supreme Court of Florida where the court held that printing or having printed on someone's behalf stationery, which identifies them with the initials JD, and using that stationery to correspond to opposing parties or other people about legal matters, constitutes the unlicensed practice of law. So that I would not recommend doing that either. And then also, as far as the social media sites are concerned, using the JD is problematic, and it would also be problematic for her to be answering legal questions or providing answers to legal questions to members of the general public while she is not yet licensed to practice law. In a real-life scenario, this was a hybrid of two real-life situations. The first one, a law school graduate posted on Facebook and another social media page that she was an attorney before she had actually been licensed. And in the second, a law school student was posting responses to inquiries from lawyers on a listserv. He always identified himself as a law clerk and used an email address different from that of the firm where he was employed, but he was giving legal advice about the law and practice procedures to others who were subscribed to the listserv. In that case, the disciplinary authority contacted the firm and spoke to the law student's supervisor and strongly recommended that the law student should cease his behavior unless he wanted to compromise his future admission to the bar. Recently, in 2013, a matter was brought to the attention of the Unlawful Practice Committee of a state bar, and it involved two law students who had started a business venture in the town of the law school where they both were attending at the time. The law students started the business, and the business was to undertake acting on behalf of students in a well-known and very established college town. They created a website detailing their business and the services they offered, which included representation in landlord-tenant disputes, premises inspections, et cetera, et cetera. The matter was presented to the committee for the purpose of investigation. After the Unlawful Practice Committee reviewed the website, they contacted the law students and informed them that if they actually provided the services that they advertised on their website, their business would cross the line into the unlawful practice of law. The two students responded, and they stated that they were not representing clients, and that up until that point, they only had one case that they had handled. The committee asked the students to come before them to further give them details about the operations of their business. The students did agree to the request. However, before the meeting took place, the students decided to dissolve their business venture. So it's not a good idea to start these types of business ventures where it could be perceived that you're jumping the gun, you're giving legal advice, you're offering legal services. Again, because in the long run, it is not worth it because, first and foremost, it could hold up and possibly preclude you from being admitted to the bar because of the investigation. The third scenario we're going to look at is when a law student or law school graduate is working under the supervision of a lawyer, and effectively the law student or law school graduate is practicing law, and so we're going to determine how far that law student or law school graduate can go. And this is a hypothetical with another live poll. A recent law school graduate clerked at a firm during his third year of law school and was recently hired full-time. The state's rules allow third-year law students and new graduates to appear in court and perform other services provided that they are under the direct supervision of a lawyer. After the graduate was hired full-time, the firm changed its website and letterhead to include the new lawyer under the list of attorneys employed at the firm. Has the graduate done anything wrong? And it looks like the majority of you voted that no, the graduate hasn't done anything wrong. The correct answer to that would be yes, because unfortunately, as the graduate's future is in their hands, and they can still be held accountable for what a supervising lawyer or employer does if they don't take any steps to stop the action. What the graduate should have done was to approach the supervisor or the managing partner, express their concern, ask that the letterhead include either a licensing date or some other indication that the person is not yet licensed, just to make sure you document the conversations to make sure that you have a record of that. Because technically the graduate is still engaging in the unlicensed practice of law when they're working at the firm. However, the conduct has been authorized, but it's been authorized with restrictions. However, once the graduate goes beyond those restrictions, then the conduct becomes unauthorized, and so it becomes unlicensed and unauthorized. So it's never a good idea before you are admitted to that bar to have your name on letterheads or in the section, the attorney section of a web page and things of that nature. I did have a case, a real-life case, where a firm did put the graduate's name on the letterhead and also had her on the firm website under the attorney section. She was waiting on her results and also waiting on the fitness and character screening. It was the Board of Bar Examiners actually that brought the letterhead to the attention of the UPL committee for further investigation. Once the file was opened, the managing partner did reach out in that case and explain that the office manager had taken the steps prematurely and the bar matter was resolved. However, the graduate still had to deal with the delay in her admission because the complaint was opened, and the graduate still had to answer to the Board of Bar Examiners because the complaint was opened. So the Board of Bar Examiners, whatever committees conduct the character and fitness processes, they're very serious about it, and they don't take the matters lightly. So in the interest of saving yourself some time, some headache, and in some cases a lot of money, it would be best not to jump the gun and to have your name placed on the roster of attorneys until you are actually admitted to practice. And a slight alteration to this case, one day the new lawyer is set to meet his supervising lawyer in court. When the case is called, the supervising lawyer is not there with the client. The judge calls up the case again, and the judge threatens to default the case if no one steps up on behalf of the client. So what actions should the law school graduate not take at this point? Regardless of the fact that the graduate is allowed to appear in court, the requirement for direct supervision by a lawyer is not met at that point because the lawyer is not there and the graduate is there on their own. Some people may argue that the graduate was directly supervised in preparation for the hearing and that the graduate should act in the best interest of the client to avoid any default. But the requirement for direct supervision, it applies to all stages of the representation. And so if the lawyer is not there to supervise the client, then the graduate should not and could not act. Really at that point, the most that the graduate could do would be to speak with the judge, let the judge know about his or her status, that they're unlicensed, they're a graduate, and let the judge know that the supervising lawyer is not there, and perhaps ask if the court will give them a brief recess to reach out and try to find the supervising lawyer or some other lawyer from the law firm or from the office that can appear. There are some jurisdictions that do permit non-lawyers, graduates of law schools or even second or third years to appear on behalf of clients and to essentially practice law. But again, the conduct has been authorized by some statute or by some rule. For example, in Florida, third-year law students and law school graduates can be considered as certified legal interns. And in most cases, that requires them to have successfully completed a legal clinic while they were in law school, and then they can then in turn practice under the supervision of a member of the bar, either usually in the office of the state attorney or in the office of the public defender. But again, the key to it is that it has to be under the supervision of a member of that particular bar. So it's important that to know that law school students and law school graduates who have not passed the bar and who have not been sworn in are treated as non-lawyers in all jurisdictions. Just as law school students and any other member of the general public are considered non-lawyers, they're all considered non-lawyers as well. And in any case where a law school student or a law school graduate can perform any legal work that it can be construed as the practice of law, the key is that it should be done so under the direct supervision of a lawyer when it's permitted. When they're permitted to do that, then they make sure that they have that supervision of a lawyer. And how far you can go under the supervision of that lawyer depends on the rules in that particular jurisdiction. For example, some jurisdictions like Illinois and Missouri allow third-year law students and graduates to appear in court and conduct certain legal work for pro bono, not-for-profit, or government entities if they're properly certified and operating under the direct supervision of a lawyer. As I mentioned earlier, Florida also has certified legal interns who can do that. Some jurisdictions like Texas allow such activities for a private firm. Many other jurisdictions restrict any acts considered the practice of law until that individual has actually been sworn in. So the key is you have to know the rules of your jurisdictions because they vary widely on what activities are permissible and at what stage those actions are permissible, whether it is as a law student versus being a law school graduate versus being a graduate who has received their bar results and a graduate that has not, whether it's the second year or third year, et cetera, et cetera. So be very careful. And as far as communicating your status and communications regarding your status, you should avoid any information that could be construed as false or misleading. And remember that the standard is typically what a reasonable member of the public might think, not necessarily a reasonable member of a bar. A layperson may presume that a JD entitles someone to give legal advice, to represent them in court, to draft pleadings and contracts and other legal documents on their behalf, and they may not know the distinction between having a JD and actually being admitted to the bar. So you have to look at it from the perspective of John Q. Public and not necessarily looking at it from the perspective of a lawyer who you would assume and presume would know your status as not being admitted to the bar yet. Also keep in mind that lawyer disciplinary agencies and UPL commissions and lawyer admissions agencies are all under the supervision of your state's highest court, and they all also work together. So if your supervising lawyer or the managing partner puts your name on their letterhead without the proper designations, or they jump the gun and put you on the attorney section on their website, and that information then gets communicated to the lawyer disciplinary agency, it will then also be communicated to the Board of Admissions, and again, potentially delaying or in some cases even preventing your admission to the bar. And in the end, it is not worth it. In some cases, the managing partner or the supervising lawyer, whoever it may be, they may do the mea culpa and say, it was my fault that this happened, but you can't always count on that. In some cases, they may decide not to fall on their sword for you, particularly if the lawyer regulation section has a complaint open on them. They may decide to look out for themselves. So in scenarios like that where you get hired and you learn that something has been done where your name has been placed on letterhead or some other capacity as lawyer, you should take some steps to bring that to their attention and let them know. You should also keep in mind that character and fitness committees do take their jobs very seriously. They may be called something differently in each jurisdiction. For example, in Florida, it's the Board of Bar Examiners. In some other jurisdiction, it's the Character and Fitness Committee, but they do take their jobs very seriously. And while the rules of professional conduct technically only apply to licensed lawyers, law students and law school graduates are also expected to adhere to them. So if you violate those rules and engage in UPL, that would alert the Character and Fitness Committees that perhaps you might be someone who could be a problem down the road. And again, at worst case scenario, to prevent you from being admitted to the bar, or at a minimum, create an unwanted, costly, and time-consuming barrier for you to get into the bar, and it would delay your admission to the bar. Also keep in mind that these committees also run internet searches during the process of going through your background check, so be careful what you put out there on the internet. I have received inquiries and complaints from the Board of Bar Examiners based simply on information that they have received from an internet search engine where the law school student or law school graduate is holding out as a lawyer and possibly offering legal services. So don't think that their search is just limited to the information that you provide to them. They take it 1, 2, 3, 4, sometimes 5 steps further in going into your background and in terms of what you're doing now, how you're holding yourself out, particularly in this age where pretty much everything is out there as far as social media, the internet, and things of that nature. So it really isn't worth it to start up a web page or to be offering legal advice to your friends on Instagram or Facebook. And also remember that as a law school student and a law school graduate, for better or for worse, you are held to a higher standard because of that position. And members of the public, members of the judiciary, they will hold you to that higher standard. So as you matriculate through law school and as you graduate and as you sit for the bar exam, govern yourself accordingly and try to avoid any situation where it might be considered the unlicensed practice of law for you. And with that said, I wish everyone the best of luck, those who are students and who are soon to graduate or waiting to sit for the bar exam. I'm going to turn it over now to Meredith for the question and answer session.
All right, great. Thanks, Janice. So if you have questions, be sure to just type them into the window in the webinar control panel. While we give people a minute or two to get their questions in, I have a couple of questions for you, Janice. My first one is just coming out of the first hypothetical where you're considering doing a little legal work for your favorite uncle. I assume all the same principles apply to doing legal work for yourself. Is that right? I mean, it's still just unpracticed work. Nothing changes because it's done for yourself.
No, you can do legal work for yourself. In most jurisdictions, you can always go pro se. Just make sure that if you're filing anything with the court or whatever, let the court know that you are pro se. But you can always do stuff for yourself on your own behalf.
Got it. Thank you. Okay, we have one question that's come in so far. You talked about putting the JD designation behind your name in that interim. And the question is just, when can you put the Esquire designation behind that?
I think different jurisdictions have different positions on this. But in Florida, typically when we've had some cases that have come before us as far as putting the Esquire, I would err on the side of caution and wait until you're actually admitted to the bar to put Esquire behind your name. It's one of those things that have sort of been argued, and some people have argued, the origin of the word Esquire and going back to the Old English meaning and things of that nature. But as far as Florida is concerned, we have had instances where people have used Esquire and the perception has been that they are a member of the bar and they were not, and so a UPL inquiry was opened. So I would stay away from putting that until you're actually admitted.
Great, thanks. Next question, coming out of the third hypothetical, you talked about it, that it's the law student or law school graduate's responsibility to make sure the supervising lawyer is present in court. And the question is just, what is the scope of that responsibility? So you have to make sure the lawyer is present, but you're not necessarily responsible for the quality of that lawyer's supervision, right?
No, you're not responsible. The law school graduate is not responsible for the quality of the supervision, but just the main point in that scenario is that the graduate cannot engage in the practice of law outside of the supervision of that lawyer. Whoever that lawyer may be who's supervising, they cannot engage in the practice of law. So even if it may come down to the judge threatening to find the person in contempt or default judgment or whatever the case may be for the client, the graduate is still not permitted to practice law. They still have to adhere by that under the supervision of a lawyer requirement.
Got it. Okay, next question. What if you don't plan on taking the bar and instead you want to work for a corporation in-house in their counsel's office? In that scenario, can you put JD on your letterhead, or how would you what would you put on your letterhead?
Well, different jurisdictions. I know in Florida we have like authorized house counsel, where there are certain requirements if you're going to work in-house for a corporation as counsel. Generally, that means that you're not licensed in that particular state, but you are licensed in another state. So if you're going to be working as counsel, typically you're licensed in a state. You would simply have to make sure that you put some disclaimer language on the letterhead If you're working in Michigan but you're licensed in Florida, you should put some disclaimer language, only licensed in Florida, not licensed in Michigan. And typically, if you're working as in-house counsel, you wouldn't be handling like litigation matters or anything like that. It would be all internal matters, but if you do have to communicate with someone, just include some disclaimer language indicating that you're not licensed in that particular jurisdiction or that you're only authorized house counsel for this particular firm. But generally, most of the states have their own requirements as to what you can put on there as like an authorized house counsel.
Great. Next question. This gets at just the nature of what constitutes legal advice. So the question is, if in Florida, for example, you advise someone to buckle your seatbelt because you know that's the law in Florida, is that considered the unlicensed practice of law?
Generally, no. I mean, just telling someone to buckle their seatbelt, no. That there wouldn't be an issue where someone could say, well, they gave me legal advice by telling me to buckle my seatbelt. Usually, when we deal with the unlicensed practice of law issues, it's more so where someone is having like a legal problem, estates and trusts, or with a will, or with a divorce, or something to that effect, and then they ask a question of someone. And so if that person then, or bankruptcy or something like that, if that person then takes it upon themselves to do some legal research as to those specific facts of that person's specific case, and then give them guidance on it and tell them what they should and should not do, then that is the practice of law. But simply telling someone to buckle your seatbelt, simply because that's the law in Florida, that in and of itself wouldn't necessarily rise to the level of a UPL complaint.
Great. Any other questions? Those are all the ones that have come in so far. All right, we'll end it there then. Thank you everyone for joining us today. Take care and have a great day.